should you even go to the BVA? So you file a claim at the regional office, you get denied. At that point, you have three options. You can refile a supplemental claim, you can ask for high level review, or you can go to the board. So Carol, what are your thoughts on?
Well, the thing is, before we automatically went to the board because we usually always got a better decision. Now we don't want to go to the board because we know the case is going to be there. If they're 5 years now, God knows how long it's going to be before they get to them. So the first thing I consider is, can I actually get to the board? Okay. Do I have, so what I do is I look, is my client 75 or older? Does he have a terminal condition? Or is he homeless? Does he have a Purple Heart? Is he suicidal? Is he in bankruptcy? Does he have eviction, foreclosure? Have utilities been cut off? I've been able to move it when I've had, and I find this unfortunately a lot, where an elderly parent is physically and monetarily taking care of their disabled veteran son, and the VA will move them for that. If you have a Purple Heart, if you are a POW, if you have Lou Gehrig's disease, Medal of Honor, they will move those cases. And as soon as I see those, then I go into the BVA if I've got my evidence. If I don't, then I think about what's the best thing to do. So, go ahead. And also,
I feel like what she started with was the exception, right?
Right.
I mean, you're looking nitty gritty on each case, and those are exceptions she's looking for.
If you can find one of those, I can go to the BVA. If you can't, then I'm working at the regional office. But another thing that we wanted to point out, claims you should not take to the BVA. Before, you could take these to the BVA and they would be remanded, okay, because they were connected to outstanding claims. Now they don't do that. So if you have a claim for unemployability and you don't have a rating, or you don't have like a scheduler rating where you need 60% for one problem,
right,
and 70%, a combined 70 for, they will deny the claim. They won't send it back. And they will do it as of the date you filed the claim. So they said you were denied. At that time, you had no ratings or you didn't have sufficient. Even if now you have all those ratings 8 years later, they're still going to deny you. Even if those ratings went back to prior to when you filed this claim, they're going to deny you. Aid and attendance is another one. If you don't have 100% rating at that time, they're going to deny you for a lack of 100%. They're not going to evaluate the actual claim. So those claims don't take to the BVA. I keep circling them around in the regional office until I get the rating I need for either one of those.
And how do you circle it in the regional office?
Well, I wait a year if I have to, because I have cases where the basis for the disability is mental and it's stuck at the BVA under the AMA. And so it will do no good for me to file for TDIU or to file for aid and attendance because I still don't have that rating. So I will wait the whole year and then I will file the HLR. And if that's denied, I wait a year and then I file a supplemental appeal and I put in new evidence. I either get new medical records, I get statements from the veterans. Unfortunately, what they've done to us has caused us to do crazy things like this.
Yeah.
So.
But I'd say overall, considering when to go to BVA, you do not want to go. You want to do everything you can not to go. Carol laid out the specific, very singular instances in which she would go. They're essentially all advance on the docket reasons. Okay.
Right.
But if you're just a regular case, which 98% of the cases are, you need to figure out, is there a way you can just kind of churn in the regional office and get the evidence you need and get what you need to win there, because you're going to get decisions much more quickly there than at the board.
And with these exceptions, you're going to get a decision probably within 6 months.
If
Could
you,
be up
if
to
you have
year.
an exception.
If you have an exception, 75 or older, terminal, they are actually working on those. But then here's the last question. When you go to the BVA, which level do you pick? This is not an easy thing for this vet-friendly system that they have anymore.
What levels is that, Carol?
Well, I'm saying
So you have direct.
You have direct. You can go to the direct, and that means they were just supposed to make a decision with the evidence was in there. And remember, that means that say you got a rating decision and then you put additional evidence in and then you filed a direct, they're not considering that evidence you put in. They're only considering the evidence that was in the file at the time that the decision was made. Okay. Next could be a 90 days from what? So you have 90 days to submit evidence. So if you had a rating decision, and then let's say you filed a HLR and then you put a whole bunch of evidence in, and then you filed the BVA, they're not going to consider any of the evidence except the evidence that was in the file for the first rating decision, or any evidence you put in within 90 days of filing the BVA appeal. So you have to be really careful with these people. You know, I used to, if I got a rating decision denied, I collected all the evidence and then filed the BVA appeal. They're not considering any of that. I have to resubmit it after I file
Even
the
though
BVA.
it's already in there.
Even though it's already in there. And then the final one is the hearing. When do you put the evidence in with the hearing?
It's after the hearing.
Right. You have 90 days after the hearing. And here's the question I'm not sure of. What if you waive the hearing? I'm assuming you have 90 days after you waive the hearing, but I haven't gotten a decision on that, so I don't really know.
And of those, again, as Carol said, they're across the board delayed. They're not making decisions on any of them unless it's an advance on the docket. We still strongly recommend, if you have all the evidence in there and there's nothing else you needed, you go direct. Okay. Because once they start paying attention to these decisions, those are the ones they're going to knock out first. If you need evidence, we would say do the 90-day additional evidence. There is no reason.
There is a reason. I've had clients come to me the day before their appeal is due, and I know they need to go to the BVA. I don't know why. In some situations, you just have to go to the BVA.
Okay.
And that's when I file for a hearing, because I can't get evidence within 90 days. I don't even have their claim file. So I have filed asking for a hearing in certain situations, but I'm telling you, it's been because I had no other choice.
She didn't ask for the hearing because she wanted to go have a hearing in front of the judge. She asked for the hearing because of the evidentiary restrictions on timing on when she could get it in under the other option. So, but just know this, the whole need for a hearing, you got to ask yourself, do you want your benefits or do you want to see somebody? And when you see somebody, that person's not going to be informed on your case. It is one of the most anticlimactic events you would have in your life. Trust me.
And they may not be making your decision. I mean, you don't even know who's going to show up.
Doing it. So
if you want to yell at somebody, go ahead.
You're going to hearing, right?
Yeah,
but it's not. It is a way to delay your case,
and it's a waste of time.
Yeah, a complete waste of time.
So those are the things to think about, because the BVA, it is so tricky now what you should do. And I feel so bad for my clients when we're back 4 years ago. I believe the VA was getting these decisions. It was happening, and now we're stuck up there because if we withdraw the case, we've lost all those past years past due. So the BVA has us in a horrible situation.
Over a barrel.
Over a barrel. So